Move around.
I'm just trying to think, I need action into those windows. I'm glad the
I know.
blinds are closed.
I mean, you guys can move wherever.
I'm gonna reverse that one.
Yeah, see the one that needs to be reversed. We're not gonna have a jury, so I don't want to shoot in this direction. So, I'm just gonna move along here.
Okay.
Thank
And the
you.
Diaz, you can be right there. And Greenway will be right here. Correct? Yep. No problem.
And then for your argument, I'm just gonna ask you to keep your cup off the table. You can keep it on there for right now, but we've got a video.
I'm not calling them to reverse that. It doesn't have
Oh. It doesn't have a stick, that's probably why it's like that.
Live link, right? Live, right.
Yeah, it's already in process. It's done.
Okay.
I never noticed that. I know what it's like. How are you?
Good, how are you?
Of the 2022 Lawson competition, I am really delighted to be here to celebrate all of the wonderful work that has been done in this competition. I appreciate you joining us both in person and via the live stream as we really do celebrate the Mercer Law students who participated in this competition. As you know, the Lawson competition is an intra-school competition that's exclusively for first-year law students and provides students the opportunity to develop their critical reading, legal reasoning, and communication skills. In each round of the competition, we have seen advocates present thoughtful and creative points that are grounded in the facts, the law, and public policy. In addition to thanking you for joining us today, I want to thank those who've made this competition possible. And I want to apologize in advance if I inadvertently leave someone off this list. I want to thank the members of the Advocacy Council, the Director of Advocacy, Katie Powers, Laney Houston of the Dean Suite, our IT team of Chris Osier, Justin Powers, and Evan Wilson, and all of our volunteer judges, many of whom were here in the afternoons and evenings. I also want to thank each of the first-year law students who participated. Every participant showed dedication and commitment to gaining that expertise in what is a relatively new subject matter topic for them, but also thinking how to persuasively present that information from what I understand to be very active benches with lots of pointed questions. I also want to thank Will Dasher, who is this year's Lawson competition editor. He's going to share information with you about this case and introduce us to our two fantastic finalists. Will?
Thank you, Dean Stead, for the welcome. Good afternoon, and thank you all for coming. To support these outstanding future Mercer lawyers, the Mercer Advocacy Council, and Mercer Law School. A little over a month ago, we had our How to Moot meeting here at the law school, and that meeting was the Mercer Advocacy Council's invitation to our first-year students to try out for a Moot 14. It was also the meeting that told them about what brings us here today, the Hugh Lawson first-year Moot Court competition. The month that followed that meeting was filled with not just these competitors here today in the championship round, but 31 outstanding students who committed to honing their skills in the art of appellate advocacy. Appellate advocacy, I would say, in my opinion, is the Super Bowl of the legal profession, because the decisions of our highest courts are the rules of law that provide the scope of our rights as citizens of this country. The people who argue what that rule of law should be are appellate advocates. Nearly every case that a first-year law student reads, and that's a lot of cases, was decided by an appellate court. Over that month, those 31 students prepared and learned how to argue in front of an appellate court. After the preliminary round, we narrowed the field to 16, then 8, then 4, and now we are down to 2. To my left, arguing on behalf of the petitioner, is Ms. Nayeli Diaz. Ms. Diaz is a native of Pembroke Pines, Florida, went across town to get her undergraduate degree at Florida Atlantic University. And while she was there, she ran a volunteer program for 2 years, partnering with nonprofit organizations around the South Florida area. And we are so thankful to have her here with us at Mercer Law School. To my right, arguing on behalf of the respondent, is Mr. Stephen Greenway. Mr. Greenway is a native of Marietta, Georgia, and obtained his undergraduate degree at the University of Georgia. Mr. Greenway also served our country for 4 years on active duty as an infantry officer in the United States Army. Please join me in applauding these outstanding students for their incredible work in this competition at Mercer Law School and to their community and their country. Now, what is this competition litigating? This case is the matter of the estate of Meredith Palmer, the petitioner, versus Scranton Studios and Resorts, Incorporated, the respondent. On the night of October 5th, 2021, Meredith Palmer, an 80-year-old woman, was staying at Scranton Studios while visiting her daughter and son-in-law. In building their resort, Scranton Studios built lagoons on their property, and these lagoons were inhabited by wild alligators. During her stay, Ms. Palmer took an evening walk by one of these lagoons, and that was the last time that she was seen or heard from alive. She was found dead floating atop the lagoons in the early hours of October 6th, and based on the medical examiner's report, the cause of death was decided to be due to a alligator attack, specifically an 8-foot, 650-pound alligator. But Scranton Studios had a policy that it would remove alligators in excess of 7 feet due to the high likelihood of fatal attacks by larger alligators. And just a month before this incident, Scranton Studios removed a 10-foot, 700-pound alligator from one of its lagoons. However, Scranton Studios provided all guests to its property pamphlets and materials warning guests of potential dangers from alligators when they are fed or nested. They installed no swimming signs on the property to prohibit guests from swimming in the lagoons. And additionally, evidence was presented that Ms. Palmer was terrified of alligators, wanted to go nowhere near alligators, and had a normal respect for wild animals. Ms. Palmer's estate filed suit against Scranton Studios under the theory of premises liability. After discovery, Scranton Studios moved for summary judgment to have the case adjudicated by the trial court as a matter of law. That motion was denied by the trial court. So Scranton Studios appealed to the Mercer Court of Appeals, who reversed the trial court and held that the motion for summary judgment should be granted. The estate of Meredith Palmer then appealed to the Supreme Court of the state of Mercer, seeking to overturn the Court of Appeals holding. This Supreme Court granted Palmer's writ for certiorari, and now the court will hear arguments to decide whether this case is decided as a matter of law in favor of Scranton Studios, or as a matter of law, the case should proceed to a jury trial, which would be favorable to Ms. Palmer's estate. Before we let our judges in the room, I would like to ask all of you to please silence, power off, or place your cell phones on do not disturb mode. These competitors have worked so hard to get to this moment, so it would be very unfortunate if any phones were to ring and disrupt the competitors or judges' concentration in what is a complex legal issue. Thank you for your courtesy on that. And finally, before we let our judges in the room, and as a display that while these competitors are about to litigate this matter zealously for their clients to this Supreme Court, they are both part of the Mercer Law family and colleagues. Both competitors will now shake hands before we kick things off. Competitors, please shake hands. Thank y'all. At this point, we're going to let our judges into the courtroom. So all rise.
Thank you. You may be seated.
The Honorable, the Chief Justice and the Associate Justice of the Supreme Court of the State of Mercer. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the State of Mercer, are admonished to draw near and give their attention, for the court is now sitting. God save the State of Mercer and this honorable court. We will now hear civil action number 12-1234, the estate of Meredith Palmer petitioner versus Scranton Studios and Resorts Incorporated respondent. Our counsel for both parties present and ready to proceed at this time.
My name is Nayeli Diaz. I will be representing the petitioner and I'm ready to proceed.
Stephen Greenway, counsel for the respondent, ready to proceed.
Counsel for petitioner, to save you some time in your argument, will you be reserving any time for rebuttal this afternoon?
Yes, Mr. Dasher, the petitioner is requesting 1 minute for rebuttal.
Thank you. Justice.
Bailiff, if I can get you to please turn around that podium for us.
Oh, thank you.
Petitioner may come forward.
Thank you, Chief Justice, your honors, and may it please the court. My name is Nayeli Diaz, and I will be representing the estate of Mrs. Palmer, the petitioner in this case. Your honors, this case is about a deadly alligator attack that took the life of Mrs. Palmer on October 5th, 2021, on the premises of Scranton Studios Resorts, where visitors are relied upon to report life-threatening alligators. Your honors, the standard in this case is one of de novo, as there is genuine disputes of material fact at play. And under these circumstances, the estate of Mrs. Palmer respectfully requests that this court reverse the appellate court's decision to grant summary judgment for 2 reasons. The first being that Scranton Studios Resorts had superior knowledge in comparison to Mrs. Palmer of dangerous and large alligators on the premises. And the second being that Scranton Studios Resorts did not take the reasonable steps as to meet its duty of care to protect Mrs. Palmer from harm. To my first point, Scranton Studios Resorts had superior knowledge in comparison to Mrs. Palmer of the dangerous alligators had on the premises. If the court may look to page 7 on the record, it states that Mrs. Palmer never explicitly shared that she had a full understanding of dangerous.
But
and
she
large-
did, counsel state that she was aware that the property on that same record site was inhabited by wild alligators. How is that not fully understanding?
Your Honor, we are in agreement with the dissent's opinion that some knowledge is not plain, palpable, and undisputable evidence as to show that Mrs. Palmer had an understanding of the threatening alligators on the premises. If the court may look to page 11 on the record, the court will find that there is no competent evidence established by the trial court to show that she had an awareness of alligators over 7 feet on the premises.
So is the delineation the 7-foot delineation? Is that what you're asking us to adopt?
Your Honor, we're asking you to please allow this case to go to a reasonable jury because of Mrs. Palmer's unequal knowledge in comparison to Scranton Studios. If the court may look to McKnight versus Guffin, a Georgia Court of Appeals case from 1968, the court will see here that in this case, the invitee had previously been on the premises visiting for 2 to 3 months prior, and this invitee had on occasion encountered the stepping stones which caused her accident, stubbing her toe. This is not the case here, Your Honor. Mrs. Palmer.
Right, and isn't McKnight really a case for the respondent? It doesn't necessarily support your position. Would you agree?
Yes, Your Honor. However, we would like to point out as petitioner that the invitee was a second-time visitor and she was not as familiar with these premises. And although on a previous occasion, she did encounter an alligator on the side of the road, she still, as mentioned before, did not have awareness of alligators over 7 feet on the premises.
But doesn't a reasonable person know that where there are smaller alligators, there are likely larger mommy and daddy alligators?
Yes, Your Honor. The majority opinion contended this, that where there are small alligators, there are large alligators. However, Mrs. Palmer was not put on sufficient notice as to protect herself and practice ordinary care because of her lack of knowledge.
But how can you say that Scranton Studios had superior knowledge? You said earlier that Scranton Studios depends on reports of guests to know whether or not there are alligators that need to be removed.
Yes, Your Honor. To answer this question, if we may look to American Cinema versus Brown, a Georgia Supreme Court decision from 2009, we will see here that the theater was found to be in a better position than the invitee to assume risks and to have solutions to the risk of wet floors where high traffic populations came in. Your Honor, similarly here, Scranton Studios Resorts is a theme park and resort where high traffic populations regularly come in. We would argue as petitioner that they were on a higher duty of care that was owed to Mrs. Palmer as to practice ordinary care to protect her. Your Honor, this brings me to my next point, that Scranton Studios Resorts did not practice reasonable steps to protect Mrs. Palmer and other visitors that step foot on their premises.
Counselor, didn't Scranton Studios have signs up all around the property letting people know that there are alligators there? Thus by, imputing their knowledge of the dangerousness of the situation to anybody who walked by and read that sign, including Mrs. Palmer?
Yes, Your Honor. Scranton Studios did have warning signs only at the entrance and not on site, and they handed out pamphlets and had a policy. However, we would argue as petitioner that if this pamphlet was to be given to a child or a person who was visually impaired, for example, this would not be sufficient enough as to protect.
But that's not what's before this court, though. There's no issue below at the trial court level that your client could not appreciate the risk.
Yes, Your Honor, we would say that our client did not assume the risk. If we look to George versus the United States, we'll see here in this case that the defendant only took one step, and that was to remove alligators from one area to another, where they had an open pond and had users who knew of the natural habitat where alligators are there. However, the invitee was not found to have assumed the risk despite having some knowledge.
Well, you've said several times that the respondent had superior knowledge. Where in the record does it demonstrate that the respondent had superior knowledge to that of the petitioner?
In the record, it states, Your Honor, that Scranton Studios a month prior, and this is on page 10, a month prior removed a 10-foot, 650-pound gator from the premises. And so we as petitioner assert that and on page 6 to continue, it states that the Scranton Studios Resorts only inspected their vegetation. So with this information together, we believe that if Scranton Studios had taken the reasonable steps to not only inspect their vegetation.
But is that the standard though for superior knowledge, just that they had removed one 10-foot, 700-pound alligator? Is that where you're asking us to draw the line?
And doesn't that removal suggest that if they had known of this 8-foot alligator, they would have removed it as well?
Your Honors, I will answer these questions in order. So for the first question, Your Honor, we would believe that if there is a line drawn where they have open and notorious notice that Mrs. Palmer did not have in her pocket. And Your Honor, we believe that if this alligator would have been removed due to taking the reasonable steps to inspect not just the vegetation, but the lagoons as well, where they knew a naturally dangerous alligator to reside, they would have been able to find this alligator before it even got to Ms. Palmer, and Mrs. Palmer would have been here with us today. All alligators pose a risk. However, this one in particular was highly dangerous. As we can see on page 6 of the record, Dr. Schrute reported that Mrs. Palmer died within minutes from having both her right hands bitten off, both forearms bitten off, and both feet bitten off.
To go back to what you said about assumption of risk, how can you say that Ms. Palmer did not assume the risk when she went walking along the lagoon at 9 p.m. at night?
Your Honor, firstly, to answer your question, we would say that this is a theme park and resort. They are welcoming visitors to roam about their premises. And if we look to the Georgia Supreme Court decision of Robinson versus Kroger, we will see that in this decision, the invitee was found not to have gone against her ordinary care only because she admitted that she did not look to the ground to see if there was any supposed to avoid her accident. Similarly here, Mrs. Palmer, although she admitted that she had a fear for the alligators, this does not necessarily mean that she had knowledge that was equal to Scranton Studios Resorts, whereas Scranton Studios Resort had all this information and did not take the steps and had.
But isn't missing something in front of you that you slip and fall over different from taking an affirmative action to actually go out on a lagoon at night?
Your Honor, we will respectfully disagree because Mrs. Palmer was being welcome to do so, as this is a place of entertainment.
How is she being welcome to do so when there's a no swimming sign? I guess I'm really struggling over how there was a genuine issue of material fact at the trial court level.
Your Honor, Mrs. Palmer was not swimming, she was walking, and these, as mentioned before, this information given with the pamphlets and the warning signs did not go into much detail, and they relied completely upon their employees, and these employees themselves were not even trained, as they treated her cry for help, as stated on page 10, as a bird call. And so for these reasons, Your Honors, Mrs. Palmer respectfully requests that this court reverse the appellate court's decision to grant summary judgment because Scranton Studios had superior knowledge in comparison to Mrs. Palmer and did not take the reasonable steps as to protect her from harm. Thank you.
Counsel for the respondent.
Thank you, Chief Justice, and may it please the court. My name is Stephen Greenway, and I represent the respondent in this case, Scranton Studios. Your Honors, the entirety of the petitioner's argument is predicated on the idea that had Mrs. Palmer known that an alligator in excess of 7 feet were at the lagoon, she would not have embarked on her walk on the night of October 5th. Your Honors should reject this argument and conclude that the motion for summary judgment should be granted in this case under the standard of review of de novo for 2 reasons. First, Mrs. Palmer shared equal knowledge of the threat of the alligators that existed on the resort on the night of October 5th. Second, Mrs. Palmer assumed the risk when she, knowing the threat of that the alligators posed to her, willingly encountered that threat by choosing to take a walk after daylight hours on the night of October 5th. To my first point regarding Mrs. Palmer's level of knowledge, the case of McKnight versus Guffin, a Georgia Court of Appeals case from 1968, establishes that the standard for knowledge in Georgia is knowledge of the existence of the threat, not the contours of the threat.
Well, how does she have knowledge of the existence of the threat when it's unrebutted below on the record at page 6 that your company was the one who had recently removed a 10-foot long, 700-pound alligator? There's no evidence in the record that she knew that, is there, Mr. Greenway?
I'm sorry to interrupt you, Your Honor. Your Honor, the petitioner in this case had knowledge of the threat of alligators from multiple avenues. She possessed pamphlets which the respondent provides all incoming guests. She received the benefit of conspicuous warning signs on the property. She even viewed the alligators from the safety of her vehicle and told her son-in-law, Mr. Halford, that she was afraid of alligators, that she acknowledged that alligators were dangerous. And so
does it matter then that she did not have knowledge? I'll direct you back to my question about the removal of the 10-foot, 700-pound alligator. Does that matter?
Your Honor, our position is that she had constructive knowledge of that specifically Under McKnight versus Guffin, it is not necessary that she have knowledge that a 10-foot alligator was removed. The standard under McKnight versus Guffin is existence of the danger on the premises, which Mrs. Palmer clearly benefited from warnings, conspicuous signage, and firsthand experience.
But wouldn't you say it'd be reasonable for her to believe that there was not an alligator larger than 7 feet on the property if your client informed her of their policy to remove alligators over 7 feet? It seems like it would be reasonable for her to believe that that was not a threat.
No, Your Honor, because in the warnings that the respondent provides to its guests, it warns them against larger alligators that possibly may nest on the property. So from that, Your Honor, the respondent or the petitioner in this case has constructive knowledge that larger alligators exist.
Can you tell me where that is in the record?
That's on page 7 of the record, Your Honor. And again, to a point raised by the Court of Appeals, Your Honors, smaller alligators naturally have larger parents nearby. And so a reasonable person exercising ordinary care, which is the standard of care of an invitee under Robinson versus Kroger, a case from this court from 1997, would know, exercising ordinary care, that smaller alligators have larger parents, and thus going down to a lagoon after daylight hours, one is putting themselves in danger of encountering.
Where is
that
that in
risk.
the record, though, that we are to presume that a reasonable person would know somehow that smaller alligators have larger parents? I mean, isn't that requiring us to speculate, Mr. Greenway?
No, Your Honor, because a person in this instance who sees alligators and expresses fear of them, and who receives a pamphlet saying that in this environment, a alligator it's possible for them to nest and grow larger, has constructive knowledge. But even if you hold that the respondent or the petitioner in this case did not have constructive knowledge that there was an alligator in excess of 7 feet, she still met the burden under McKnight versus Guffin of knowledge of the existence of the threat. And therefore, she is responsible for having equal knowledge. The petitioner.
What if we find against you on issue 1, do you lose?
No,
Hold against you, right?
that Mrs. Palmer did not have equal knowledge.
Correct.
In that instance, Your Honor, it becomes very difficult for us to prevail because this case is predicated on both the respondent and the petitioner possessing equal knowledge of the risk. And so if Mrs. Palmer is able to show that the respondent had superior knowledge, we would not be able to prevail.
Counselor, you are placing a lot of reliance on Guffin, right? That seems to be what you keep bringing your cornerstone to as to why you all should win. But I think the distinguishing factor in that case is that person had knowledge of that dentist office. They were familiar with it. They were going to it every day for several weeks, several months. Poor Mrs. Palmer just showed up for a vacation. She'd never been there before. At least that's what the record says. How is that not a distinguishing factor that she did have intimate familiarity with that property, like the respondent in McKnight versus Guffin?
Certainly, Your Honor. Your Honor, this was Mrs. Palmer's third visit to the property. She had received the benefit of these warnings, of these signs, of this information regarding the policy on 3 separate occasions. And so that's a way in which this case is distinguished from McKnight versus Guffin. I would also draw your attention to Beard versus Fender, a court case from the Georgia Court of Appeals from 1986, in which both the plaintiff and the defendant had equal knowledge concerning the threat of wasps on the property. And yet the court held that the plaintiff in that case assumed the risk by willingly ascending a ladder towards a wasp threat. That occurred here metaphorically. Mrs. Palmer ascended the ladder of risk, climbing over rungs of warnings and policies and procedures that she had had the benefit of on 3 separate occasions. And so this case is distinguishable from McKnight versus
Counselor, what it
Guffin.
seems like happened here is that your client told Miss Palmer that she was only going to encounter carpenter bees that she'd encountered before, and then she climbs on the ladder and encounters wasps. That case seemed to cut in your favor.
Your Honor, Beard versus Guffin, Beard versus Fender illustrates that when a plaintiff and a defendant have equal knowledge of the risk and a person willingly ascends a ladder towards that known risk, then they are liable for having assumed the risk. They have violated their duty under Robinson versus Kroger to exercise ordinary care.
How
and
can
that
you
happened
say
here.
they had equal knowledge when your client didn't even have knowledge this alligator existed because they weren't going out and investigating? So how could Ms. Palmer have had knowledge that a over 7-foot alligator existed in the lagoon?
Certainly, Your Honor. Under Robinson versus Kroger, the duty of a landowner is to exercise reasonable care to make their premises safe. It is not dispositive that the respondent in this case did not patrol daily or patrol weekly. It is in Robinson versus Kroger, the duties of the landowner and the invitee are brought into balance. That case concerns whether or not a plaintiff need to watch exactly where they step and exercise extreme care. It is analogous to the duty of a landowner in this case. A landowner is not obligated to exercise extreme care, patrolling daily or weekly for known threats. The court, as it held in Robinson versus Kroger, that extreme care was not necessary, also applies to the landowner in this case. So the failure to patrol daily or weekly is not dispositive. And to my second point regarding the assumption of risk, the respondent in this case had a 100% safety record prior to this incident. No individuals had been harmed by alligators. What was responsible for
What if it had a 99% safety rating? I mean, does that matter?
The point I'm trying to make, Your Honor, is that there was a change in circumstances that was caused by someone assuming the risk.
And isn't it there also changing circumstance though? Because the only thing that the respondents were exercising reasonable care over was the vegetation, even though you're the ones who brought the alligators to the lagoon, correct?
No, Your Honor, we did not bring the alligators to the lagoon. The alligators are indigenous to the area. And the respondent created lagoons for the enjoyment of the guests. But it's not true that as in American multi-sonoma versus Brown, that the respondent in this case somehow introduced the threat or the hazard to the plaintiff.
If you say that the lagoons were created for the enjoyment of the guests, then how do you respond to petitioner's argument that Ms. Palmer was invited to roam the lagoons and that is not an assumption of risk?
Your Honor, the respondent in this case, or the petitioner in this case, was not asked to roam the grounds at night. There were conspicuous signs that warned against swimming and near in the lagoons.
But she wasn't swimming, was she?
No, Your Honor, but again, you don't have to rule that the sign was a holistic warning in order to hold for us. And if I may just briefly conclude, Your Honors, the legitimacy of this court is rooted in its ability to uphold the rule of law even in the midst of tragic circumstances. To hold that this motion for summary judgment should not be granted and potentially open Scranton Studios to liability would violate this court's precedents and the rule of law. We respectfully ask that the motion for summary judgment be granted. Thank you.
Rebuttal.
Thank you, Your Honors. First, we, the petitioner, would like to point out that the respondent has a fact wrong. On page 6 of the record, it shows that she was on her second visitation, not her third visitation. However, Your Honor, you asked the respondent whether he was asking you to speculate as to whether a reasonable person would expect a 10-foot, 650-pound, highly aggressive alligator on the premises. However, we would like to remind the court that there is no competent evidence that Mrs. Palmer could have acted reasonably in this case to expect a 10-foot or 8-foot alligator, because there is no evidence that she knew for 7-foot alligators to be on the premises, nor did she have a full understanding of dangerous and life-threatening
Is there
alligators.
any scenario wherein we could impute for Mrs. Palmer to have equal knowledge with Scranton?
If Mrs. Palmer were to know of the 10-foot or, for Your Honor, for example, this may have put her on sufficient notice that was open and notorious as to alarm her. Thank you.
Thank you, counsel. We'll stand in recess and be back with the decision shortly. Good job.
All rise. Thank you. Give my hand. While our judges deliberate, feel free to converse with our competitors, and we'll be right back with our decision. Thank you all.
The guy is over.
Nice job. I'm glad to. Thank you. I know you're right across. I would have been out across. Very interesting.
Yeah, really.
actually really,
No,
you know, I really enjoy hearing about that. I'm not. But.
Thank you.
Very nice job. You do very well.
Yeah.
What are you gonna do? Well, you, yeah, the wasted opportunity. Please test out.
I was about to say, it has to be scary. Congratulations. Yeah, I mean, I haven't done it. You say that. Congratulations.
Thank you.
I did work. I just wanted to say, congratulations. Really nice job. Fine job. Yeah.
Well, we're not looking for. Yeah, I think yes. I know. Yeah, Ask your question.
All rise.
Thanks, you may be seated. All right, great job to both of you. I think my fellow justices have some feedback, so I'll just ask if each person will introduce themselves. We'll start with you, Ms. Booker, where you work. Thank you so much for joining us, and any feedback you'd like to give.
Sure. Hi, everyone. My name is Chanel Booker. I'm an assistant United States attorney here at the Macon U.S. Attorney's Office. Bailey is my law clerk right now, Bailey Marshall, and she's the one that wrote me into this. So thank you, Bailey. I thought you all both did an excellent job. I mean, it was just, I was really, really blown away. And just a little bit about my practice. I obviously practice in trial court, but I do handle appeals, but I've never handled an oral argument because the judges are like, we don't need to hear it. much to my chagrin. So I really appreciate that you all are developing this skill and talent right now. Ms. Diaz and Mr. Greenway, I thought you all both had a very good mastery of the record, which is very impressive to me, to be able to answer those questions that you were being peppered with and cite the specific pages and correct us when we were wrong, because I know I misstated a fact about Ms. Palmer only being there once. Mr. Greenway, I thought that your eye contact and poise and overall body language was pretty good. I think you got just a little bit nervous, which is understandable. I could see myself in you a little bit. But overall, your demeanor and command was very good. Ms. Diaz, you had the same poise and demeanor as well. Thought your responses to questions were spot on. Could tell that you were an active listener and were directing your answers right to the judge's point, as opposed to going back to what you wanted to talk about. But you eventually got back there after you directly answered the judges. So I thought that was excellent.
Well, I hate to follow that, but my name is Zachary Mullinex. I'm just a 2L here.
He's not just a 2L, he was last year's Lawson's champion. So whoever is this year's Lawson's champion gets to join the bench for next year as well. Go ahead.
Anyways, y'all both did great. I'll go in order. Ms. Diaz, you had a great use of cases and the record. I'm very impressed with that, pulling in record sites and case sites. You pronounced the case names well entirely and pulled them in. I thought you had a good grasp of the elements of the claim and the standard of review, which is very important, an appellate level argument. The only thing I would say to be mindful of is your speed. It's very easy to get going fast. You've probably heard that before, and you'll hear it again. It takes a while to get with it. And it just takes a lot of practice. And obviously I'm not great with that myself. So
Me either.
just work on it. Let's see. Yes, I also agree with Ms. Booker. I thought you were very responsive. You had great eye contact. You were very responsive to our questions, and that's the most important thing. So very well done. Stephen, I thought you had a really good intro. I thought your pace was really good. You have a good presence in the courtroom. We did rattle you a little bit there at the end. That was on purpose, at least for me. But you responded that well. I think you had an equally good use of case sites and records. So the only thing I would say for you is to, when you get to those moments where you got a bunch of stacked questions or you get kind of frazzled because there's a bunch of people coming at you, it's okay to take a pause and take a step back and think about your answer before jumping right into it. So resist the temptation to run right in with a response. But overall, you both did fantastic, especially for your first go round. So well done.
Hi, I'm Ariel Newman. I'm one of the reference services librarians and legal research professors. I want to echo everything my co-justices have said. You guys did amazing. You have a very good courtroom presence. Just remember, this goes for both of you, just slow down, take a breath, treat this as a conversation. And I think you both had great command of the record. You knew exactly what you were talking about. And I thought it was good that you let the justices kind of guide the conversation, but just make sure you do take a step back and treat it as a conversation, and that will help you.
Good afternoon. My name is Katie Powers. I'm the Director of Advocacy here. First of all, I think I speak for all of us when I say the future of Mercer Moot Court is in great hands. So we're very excited for both of you. Ms. Diaz, I thought your record sites, your knowledge of the record was really superb. And I appreciated you avoiding my attempt to make you line draw with where we draw the line. You just totally sidestepped it, even though we kept bringing you back to it. So I thought that was very good. Mr. Greenway, I thought you were incredibly responsive when you stood up. So it sounded like a respondent's argument. And you guys both will hear probably multiple comments from us in the upcoming next 2 years. So with that, I will be quiet and ask Mr. Dasher if he'd like to announce the winner of this year's Lawson.
Thank you again to our outstanding competitors and everybody who tried out this competition. This was as fun for me as I'm sure it was for y'all. And the real joy that we had in running this competition was to see y'all's growth. As y'all grow as competitors, as students, this was just an absolute treat for me to be able to, and everybody here, to witness this championship round. So the moment we've all been waiting for, in the matter of the estate of Meredith Palmer versus Scranton Studios Incorporated, petitioner versus respondent, in the round of Ms. Diaz versus Mr. Greenway by a margin of 0.1 point. Mr. Greenway, you are this year's 2022 Lawson champion. Yeah. Congratulations, sir. Well, that concludes our program. You're more than welcome to come up and congratulate all of our competitors. We'll get some pictures with them, but feel free to come up and talk to our competitors, okay? Thank you all for coming.
This is basically yours too.
No.
Point one.
Thank you guys.